attorney Jonathan Turley. He has been inside the court overflow room all morning. Jonathan, great to have you with us. So please do tell us your takeaways so far.
Well, this has been rather otherworldly to sit and watch this. It's like you've entered a parallel universe. I mean, how this case is going forward, I just cannot explain. You had a disbarred, convicted serial perjurer on the stand, matter-of-factly detailing how he stole tens of thousands of dollars from his client. And what is really funny is then the prosecutor gets up and says, I just want you to tell the jury, once again, you're not charged with anything, right? And I wanted to stand up and say, yeah, but you should have. He just admitted that he committed grand larceny. He told you that, and you instead decided he was more valuable to pursue a dead misdemeanor on a bookkeeping violation.
So, New York state law, statute of limitations on larceny, I believe, is 5 years. So Cohen said that knowing that the statute's already run and that he probably would not be charged by Bragg. But should Bragg, at the very least, look into this, Jonathan?
Well, that's the question. He's been under investigation for many, many years. So when he admitted to it doesn't really mean the fact that they couldn't have determined this. But the interesting thing about Cohen is how really blasé this all is. Yeah, I stole money from my client. I lied repeatedly. I violated all of these oaths. And people are just sort of nodding, and you feel like you're the only one in the room saying, this is not normal. Okay, this is not how trials are supposed to go. But the prosecutor then got up to try to resuscitate him and pound on his chest and, get his heart going again. And it made it even worse, because much of what the prosecutor talked about really didn't change the thrust of his arguments. Yeah. So at the end of the day, this is a shiny object that is being used to distract the jury from the fact that they have glaring problems. They had witnesses that said, look, we listed this as a legal expense because we paid it to a lawyer. You have the key role of Weisselberg, who's sitting 15 minutes from here, who was the one who said, yeah, why don't we treat this as a retainer? Which probably made sense to him because Cohen should have had a retainer, but he was a really bad lawyer. And so, like many things, he didn't do that. But now the prosecutors are using his failure as a basis to convict his client, and then he's adding to that and saying, I think you should send my client to jail for following my legal advice.
Based on everything you've just said, Jonathan, is it safe to assume you're in the camp of the former president not testifying or taking the stand himself?
No, he can't testify, but that door was closed by Judge Merchan. Judge Merchan granted such a broad scope for cross-examination, no lawyer would let a client get on the stand with the order of Judge Merchan. And I have to say, I was really struck today by what I consider to be fairly one-sided rulings. He hammered the defense, sustaining a lot of objections, some of which I still don't understand the basis for his order, and he was far more solicitous towards the prosecution. But the biggest problem that we saw today is one of the reversible issues. Once again, he allowed the prosecutors and Cohen to talk about how there are campaign violations in the case. And there are no campaign violations. And so after this happened again, he gave this instruction saying, disregard that on the merits. Well, they're not going to disregard that on the merits. They're hearing it over and again. So he says you can't have an expert on that issue. But Michael Cohen here is to lay out the federal election law, because that's practically what's going to happen.
With respect, Jonathan, I used to go from downtown Manhattan out to LaGuardia once a week, and I can't ever remember passing Rikers within 15 minutes. but I appreciate
no, that's
the
true.
reference.
You're talking to a Chicagoan, so that's right. Yeah.
So let's talk about the defense's strategy here. One person that they would like to call is Brad Smith. He's a Federal Elections Commission official. And they want him to testify about the difference between a campaign contribution, campaign expense, whatever, pointing, to some degree to the potential underlying crime here, because we still don't know what it is. Yet the judge wants to put strict limitations on his testimony. Does he just want to tie the prosecution's hands behind their back here and say, go for it, but you're not going to get anywhere?
Well, with the federal election law expert, a lot of judges would probably reach that same conclusion because it is the domain of the judge to say what the law is. The problem is what this judge has done with the rest of the case. The reason they're asking to call an expert is because Merchan has made a mess of this case. I promise you that jury believes there are federal election law violations here as a fact. And Merchan has allowed that to occur, and he gives this rather weak instruction that I think, quite frankly, is not going to have much of an impact on the jury. They're not going to unhear the repeated reference to these violations. The other question is going to be Robert Costello. I thought it was very interesting that the defense spent so much time on Costello, and they specifically emphasized how Cohen asked for information to go to Giuliani. As a defense attorney, that's the type of thing I would do if I was thinking of calling Costello, because it would negate this damaging email which refers to a back channel to Giuliani. But he also nailed Cohen because Cohen said that he didn't trust Costello, didn't tell him much, and that he only spoke to Costello maybe a dozen times. He underestimated that sevenfold. You had Blanche say, you called him over 75 times. You spent 9 hours just on those telephone conversations. And it really blasted away what Cohen said previously.
So, Jonathan, based on what you just said, is there any possibility, and by the way, the former president is re-entering the courtroom with a fist pump? All right, Jonathan, he's back in. So, based on what you just said, is there any possibility that could change, that the prosecution could call another witness?
Well, the prosecution may have to call a witness just in order to get this last document in, which they want to show a picture of the bodyguard with Trump on the day of this call. It's sort of a weird effort. It's another example of their strategy to prove things that are not really determinative or important to the case. They're saying, look, he was standing next to Trump then, so when Cohen called the bodyguard, he could have turned to Trump. The problem is the call only lasted about 1 minute and 30 seconds. And the purpose of the call was about a teenager harassing Cohen. And after the short call was over, there was another text saying that's what the call talked about. So the defense went ballistic and said, we never said that he couldn't speak to the president. We said Cohen committed perjury on the content of the call. The judge is going to come back, and one of the issues is hearsay and whether they would have to have another witness come in order to make that document work.
Yeah, well, I guess they could always call Keith Schiller if they wanted to. Professor Turley, always great to get your thoughts on things. Thank you for being with us.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.